Well, hello, everyone. Thank you so much for joining us for today's webinar on the fascinating topic of pay transparency and what it means for workplace culture. We are so thrilled that you're able to be with us today. For those of you who don't know us at the National Conflict Resolution Center, we are putting on a series of webinars just like this one with the goal of equipping workplace leaders with some skills and some knowledge as we navigate through really some unprecedented times. I think being a workplace leader today, we are navigating through topics and issues and divisiveness and polarization that we haven't experienced before. And so we really are doing a lot of thinking about workplace culture and seeking out tools, I believe, so that we can support it. And so what we're doing at the National Conflict Resolution Center is providing a series of no-cost webinars so that workplace leaders can come together, learn about hot trending topics happening around workplaces around the country, and come together to see what best practices are to continue to have the best workplace cultures possible. At the National Conflict Resolution Center, I always like to say that at our core, what we do is teach people how to have difficult conversations effectively. And so that comes up in a lot of different ways, but potential difficult conversation could be around pay transparency, pay equity, and some of the topics that we might touch upon today. So we felt this was a really applicable topic for us, and we are excited to dive into it. I'm honored to be presenting today with Rich Paul, who is a partner at Paul Plevin and Quarles, and he is so knowledgeable about all things when it comes to employment law and laws that impact workplaces. And so we're thrilled to have him here with us today. My name is Ashley Virtue. I'm the Director of External Relations for NCRC. And I've been with the organization for about 17 years. If you've heard me present before, you'll hear me joke that that's not because I'm a strange person who loves conflict so much. I just need to be around it all the time. But it's really because I truly, truly believe that through the skills that NCRC teaches, people really are equipped with tools to have challenging conversations and the kinds of conversations that we tend to avoid altogether these days, but they're really important. And so I get a lot of personal joy out of that. And I know today we'll continue that. I am going to ask Rich to introduce himself, but before I do that, wanted to engage with you just a little bit. We have a poll, and I wanted to ask you all a question. What do you know about the new pay transparency law? And really your answers are a lot, just the basics, or really I know nothing. So go ahead and answer those. Make sure you hit submit on the poll. You have to answer the question and hit submit while Rich introduces himself.
Thank you, Ashley. It's a pleasure to be with everyone here today, including I noticed a couple of people signing in from my alma mater law school up in the Bay Area. Welcome, especially to you and to everyone else. I've been a labor and employment lawyer for quite a number of years, practicing here in San Diego. I've been on the board of the National Conflict Resolution Center for about 6 years. I have taught law at the University of San Diego School of Law for 25 years in the area of labor and employment law. So these are issues we're going to discuss today that are near and dear to my heart, are things that we run into on a regular basis, and they're part of a bigger picture that requires that we think carefully about how we dialogue about it in the workplace. But first, the nuts and the bolts. Today we're going to talk about a new law in California known as SB 1126, that's Senate Bill 1126. It is effective January 1st of this year, though the reporting requirements don't come into effect until a little bit later on. And this law has two very distinct parts. And so let's start first, if you will, with the changes to Government Code Section 12999. So under existing law, Employers, private employers of 100 or more employees are required to file something called an EEO-1. And if you're a larger employer, you understand what that is. The EEO-1 form has been required by the federal government for a number of years, and it's basically a statistical report on the composition of your workforce broken down by sex, color, national origin, and certain other reporting categories. This has been part of a data gathering project by the federal government for quite some time to frankly get a better handle on what the population distributions are among various workers by job category and in job categories. Up until January 1st, it had sufficed for a California employer to simply take the federal form and submit it to California, but no more. Part one of this bill basically creates a new California EEO-1 equivalent form, but with different metrics, different categories, and different reporting obligations. This report has to be filed before the second Wednesday in May 2023, and every second Wednesday in May thereafter. So put it on your calendar, it's going to come. Also make a note that this compliance with this law requires a collaboration between HR and IT people. And a close look at your HRIS database. You have to include labor contractor employees in a separate report. That's new. You have to include pay data by reporting the median and mean hourly rate for each combination of race, ethnicity, sex within each of the various job categories. So that's new, two different ways of measuring the idea of what the middle range is. It used to be you could file a consolidated report for all of your locations, no more. This report has to be filed location by location. So if you have multiple locations within California, you have to have a separate report for each location. There are fines of up to $200 per employee not included in the report. The report is sent then to the Division of Labor Standards Enforcement. So how do you pick what data to put in there? Well, first of all, the employer gets to pick a pay week somewhere between October and December and do a snapshot of that particular pay week. That's up to you. Do whatever works for you. Do you include part-time people? The answer is yes. If they are on your payroll, they should be reported even if they may not be working that week. That's what's critical to keep in mind. You also have to report the total number of hours worked by each employee during the year. So separate and apart from the mean and median hourly earnings, you've got to report some total year data. Who is an employee for purposes of this report? Well, the definition is simply an employee is someone who's on the employer's payroll for whom the employer is required to withholding or Social Security taxes. So it's W-2 people. It is not independent contractors unless you've inappropriately misclassified them as independent contractors, then they should be reported. What about employees who work for you but work out of state? You're California-based, you have operations in Tennessee, and do you have to report on your Tennessee employees? No. Okay. What if you use a California-based payroll function for your out-of-state employees? Do you have to report on out-of-state employees? Answer, unclear, but probably not. The intent of the law is really to report on California employees. But if you have a California employee based in California, W-2'd in California, who you send to Texas for a couple of weeks to work, that employee has to be included. Remote workers, if they're payrolled in California, they need to be included. And so that's basically the new reporting law. The more important one for pay transparency purposes is the disclosure law that amends Labor Code Section 432.3. In some ways, it restates things that have already exist. For example, as I think we all know on this call, you cannot rely on salary history of an applicant as a factor in hiring or setting compensation. And that's for obvious reasons, that women have historically been underpaid. And so if you take into account what their current salary is and say, well, I'll give them 10% on top of something that's quite far behind, That moves them up to here, but the men may be up here. So the ban on salary history was to try and eliminate the effects of past discrimination. If the applicant voluntarily discloses salary history, you don't have to cover your ears. You can listen to that. And you can take it into account, but you can't prompt the disclosure. You can ask, what are you looking for? You can't ask, what is your current pay? Okay. So then point 2, on request, the employer must tell any employee, not just applicants, but anybody, the pay scale for the position in which the employee is currently employed. So that's for everybody. People come in and say, I'm paid $1,000 a week, but what's the pay scale overall for my position? You've got to report that data. And that becomes really, really important as a pay equity issue to allow people to understand what compensation is being paid for similar work being done by other people in the same general salary band. More on that later. What is the pay scale for purposes of this law? Well, is it, what you actually pay or some other metric? The law says the pay scale is, and this is important, the salary or hourly range that the employer reasonably expects to pay for the position. The salary or hourly range for the position are the key words. In a hiring situation, the position is just the position you're hiring for, not necessarily all of the other people who are in that same general line of work within your enterprise. That becomes important, it seems to me. Keep in mind, though, we have no meaningful FAQs yet from the department on what this means. So keep your eyes out for that, because that's an ambiguity that really needs to be clarified. Well, what must you include in salary or hourly wage? Side deals, probably not, except if the pay is on a piece rate or commission basis, you have to report that as well. But mercifully, you don't have to include benefits, tips, or ancillary things, stock options, things of that sort. So the most talked about part of the law is that you have to disclose the pay range in recruiting. An employer of 15 or more employees shall include the pay scale in any job posting and have its recruiters do so as well. So if you use third-party recruiters and the like. Again, pay scale is the reasonable salary or hourly wage range that you anticipate that you will pay for the position for which you are hiring. Records have to be maintained for a long period of time. Penalties are stiff, $200 per violation up to $10,000 potential high-end penalty for violation. Now, this California law is part of a nationwide grouping of laws that vary in their form, in their content, and requirements. There are essentially 3 different kinds. There are disclosure to applicant laws. There are disclosure to other employee laws. There are pay range disclosures in job posting laws. There are different triggers, different requirements, and the like. But the more aggressive and the more, I should say, seasoned versions are in Washington, Colorado, New York City has one, New York State and Massachusetts are soon to have them, posing an important question for employers that have nationwide operations or do business in some of these other jurisdictions about how you're going to decide what your disclosure obligations will be, i.e. one uniform national disclosure pattern in the interest of uniformity within the company, or state by state disclosure patterns that reflect individual differences. That's a bit of a complicated question depending how you're organized, but that's something for you to keep in mind. So that's the new law in its 2 parts in a nutshell.
Thank you so much, Rich. I want to share that as we did the poll and as you started with that answer, I think most of us were feeling like we kind of fell into the category of knowing just the basics or really nothing at all. And so I think that was really helpful to just get some basic information. There were also a couple of questions that popped up, and I think you actually answered them through that overview that you did. What I want to ask now to the audience, before I get to Rich's next question, is another question about conversations that you may have had. So just curious, for those of us here in the audience, have you had conversations about this yet as a leadership team? And while you're answering that question, Rich, let me ask you our second question. What do you feel like these new laws, and I know you mentioned it's certainly not just in California. California is following multiple other jurisdictions that have enacted similar laws with this, kind of broad term of pay transparency. What do you think is the broader implication in terms of pay equity?
Well, let's take a step backwards. Federal law under the National Labor Relations Act and Title VII has favored the right of employees to discuss openly with one another issues of pay and compensation. Employers up until maybe 10 or 15 years ago used to have rules that said your compensation is private information. You should not discuss your compensation with others. And those rules are now clearly illegal. The policy of those two agencies is that to allow meaningful discussions within the workplace about lack of pay equity, you've got to be able to talk about the numbers. To allow workers to band together for mutual aid or protection because they're low wages, you've got to allow workers to talk about the numbers. So the arc of change has long favored free communications within the workplace about pay, and then we've had the Equal Pay Act on the books at the federal level since 1963, but because it has some exceptions, it's been largely ineffective. That caused California, the leader, the anomaly in California, by the way, is we have the most pro-employee labor and employment laws in the United States, and we're about to become the world's fourth most successful economy. So maybe, just maybe, regulation of employment does not detract, from economic success. But apart from that, the California Fair Pay Act of 2016 is a much, much more stringent pay equity law that looks much more closely to be sure that men and women doing substantially similar work are paid equally, not just identical work under identical conditions, but reasonably similar work. And it narrows very much the defenses to that sort of thing. So the broader implications of these disclosure laws are that they will help get data out there to regulators who ultimately may decide to bring cases or claims, and also to regulators for purposes of study to help us better understand really what the pay gaps are. There is a lot, and this leads, I think, Ashley, to your remarks about workplace conversation. There is a lot of misinformation about the pay gap bandied about that causes people a lot of stress, frankly, in arguments. One statistic we see is that women earn 78 cents on the dollar compared to men. That is true if you measure all the earnings of all women in the United States and all the earnings of all men in the United States, divide by the number of women, divide by the number of men, and that's what you come up with. The reason being that there are more men in higher paying jobs than there are women in the United States workforce. But if you measure whether men and women are generally paid the same in equal job bands in major corporations, the statistics show that the disequality is somewhere under 4%. In other words, women generally are paid within 96% of what men are paid when you're really looking at the same job band within a company. So my point here is that within your organization, there may be hurt feelings and there may be a lot of passion around these issues. If one thinks that one is being significantly devalued using that 78% statistic. And you have to think about, how are we going to talk about this? How are we going to address this? What kind of conversation do we want to promote? How much transparency do we want to have? What is our corporate value? And ultimately, are we going to export that to our other operating units throughout the United States?
Well, and I think this leads so perfectly into the next question, which is what kind of potential impact will this have on workplace culture? And in the poll that we just took, about 71% of us said that we've not yet had conversations about this new law as a leadership team. And so I think that this is part of it as well, right? I mean, there's the nuts and bolts of the law and what to do about it. And then there's also, how is this going to impact our workplace culture? What do you think about that?
Well, I think that where you don't want to be is in a workplace in which there is a perception that while you speak of transparency, you don't practice transparency. There have been some very, very widely publicized issues involving a couple of entities that'll go unnamed in the Bay Area that had workers complain about certain practices within the company, and that those complaints went viral, and questions of the honesty and legitimacy of the corporate culture came into play, whether it really was the open and transparent workplace that it purported to be. So on a macro level, it's just a very, very difficult position to be in if you disallow conversations. Conversations will take place. And the real issue in my mind is how you shape those conversations. You will have tension, for example, between managers and enforcers of this new law. If I'm a manager, I'm given a budget and I'm saying, go hire someone within this budget. I want to get the new hire for the lowest possible amount I can, right? Because it comes out of my budget. But it may well be that you have a view that as soon as people are hired, you've got to be thinking about pay equity. Even if you could hire them more cheaply, once they work there for a while and do the same thing as other people who are incumbent employees, that pay has to be equalized. And these concepts are pretty well known to many of us who are full-time labor and employment people, but they are not well known within workplaces and require some careful training and conversation. And the starting point, I think, is with your unit leadership and the like, having them get some education as to why we're doing what we're doing in the law, how this relates to pay equity, and ultimately how it relates to a happier and more productive workplace.
So this kind of leads so well into, my favorite topic, which is best communication practices and how we can have those conversations. But another kind of nuts and bolts question, maybe before talking about the communication aspect of it, which is what would a company do if they do find through this reporting process that there are discrepancies? How do they correct, and is that information made public?
So a great question. It's a complicated problem, but here's the simple answer. If a company conducts a pay audit analysis, it can do it one of two ways, either under its attorney-client privilege, where the analysis is being done in order to enable its counsel to advise the company about whether it's in compliance or not, or it can do it outside of the attorney-client privilege, in which case, whatever it finds becomes discoverable in any lawsuit that is filed against the company. Some are of the view that the worst of all worlds is if you study in good faith everything that you've looked at, but you don't keep it privileged, and then you see, oh my gosh, we're really out of compliance. And one of the people who knows about this gets a lawyer, and a class action lawsuit is filed, and the first subpoena that comes in is for your own internal pay equity analysis report. And believe me, that happens. So my advice here is think very, very carefully about how you do it, but by all means do it, okay? Don't let the plaintiff's expert in a lawsuit be your pay equity analyst. Although there are some wonderful stories of very well-known companies who got sued and actually cooperated in the litigation and viewed the lawsuit as a way of saying, yeah, I'm ending up paying for this outside person to criticize my practices, but it had to happen and I might as well get something out of it. So think carefully. It can be a complicated process, but don't shirk away from doing it. It's really important.
I really love the concept of a company taking that opportunity to grow. I think that's pretty wonderful. Well, I think, Rich, in terms of having a 30-minute webinar to tackle an enormous topic like this, You have done an incredible job of helping us all kind of get an overview. And I really love what you said, that conversations will take place. They're going to take place one way or another. And so being ahead of that, being a workplace leader that's thinking in advance of that, I think it's important to just ask ourselves these questions. One is just, how are you addressing pay transparency with your staff right now? You may be really addressing this at the leadership level, or you may know nothing about what the leadership level is doing about this, but how is this being addressed kind of currently today as people are learning about and know about this law? And then also just thinking ahead a year from now, how will this be affecting your workplace culture? And to your point that these conversations are going to happen, I think it's important for all of us to consider the kind of workshops that we bring in. We also probably, many of us may need to consult, maybe with HR or consult with labor and employment attorneys on how to go about this. But a really important part of this that can't be overlooked is how to have conversations around this hot topic and many others like it. So I just encourage you all to really think about that as you get to that part of this conversation in your team. Think about maybe some of the workshops that NCRC offers, workshops like how to have inclusive communication. We have an amazing certificate program for workplace leaders that takes you through really navigating the most polarizing, divisive issues of our time, and how to have conversations with your team and with peers and other leadership about navigating through those things. And so I really encourage you to not forget the important step of the communication end of this, so that we can do the good work and keep our culture at the forefront. And if you don't, I always say this, if you don't do a workshop with NCRC, that's okay. Just make sure you do one somewhere. I mean, these are important skills that are really needed to maintain the good work you're already doing. Also, I really encourage you, when it comes to free resources, make sure that you are constantly checking out our social media as well as our website. We are always posting free videos and resources, articles that are on these hot topics, and they're available to you as workplace leaders. So we want to make sure that you can tap into those resources, and we keep updating weekly. So just make sure that you have access to those. Finally, just to mention that we also always have an info email that we're available to answer any questions that you have. But I also wanted to just offer my email, since I'm here and we're having this opportunity to interact a little bit today. If you want to reach out at all, we can continue to discuss. I know that Rich just answered a wonderful question online. I was going to see if we had time to get to it. I'm always very careful to be respectful of time. So if anyone else has any other burning questions, feel free to post them in the chat or in the Q&A. And that was a great answer. Rich, you amaze me. How you provided such a thoughtful answer in the 2 minutes that I was talking. That's pretty impressive.
Yeah, but forgive my spelling, okay? But the question's an interesting one. Is it equitable to offer a candidate outside of the posted range, either more or less based on notably extraordinary experiences? Say you post a range in good faith. That's what you have to pose, is what you quote expect to pay. Okay. But if someone comes in with a truly unique skill set with greater skills than the job description that cause you to see additional value in that candidate, you don't have to turn them down, in my view. Similarly, on the underside, if you post in good faith what the range would be, and someone comes in who doesn't have the skill set for the position, but you want to, for any number of reasons, have the equivalent of a learner's probationary entry level to allow them to grow into the position, I don't think this law prohibits that as well. It just requires a good faith posting of what you expect the range to be. And some employers are posting really wide ranges to protect themselves. I don't think that's a good idea. Post the range that is going to work for you, and then work with exceptions on a case-by-case basis. That's my 2 cents.
Yeah, that was a really excellent question. All right, everyone. Thank you so much for joining us today. We so appreciate your time. We hope you will reach out to us if you have further questions or want some of those resources that we mentioned. And Rich, thank you so much for joining us. We really appreciate you.
Ashley, always a pleasure.
All right. Take care, everyone. Bye-bye.